Welcome to another jaw-dropping courtroom case breakdown. Today we dive into a tense legal battle involving George Cantu, a man facing serious charges and an emotional plea for justice. But what unfolds behind the scenes will shock you. In this case, we have tampering with an electronic monitor, a history of drug abuse, and a critical moment where George's fate lies in the hands of the court. Stay tuned to witness the decisions, the twists, and the heart-wrenching testimony that will keep you at the edge of your seat. Let's get started.
Court is calling 2024 CR 0411, State of Texas versus George Cantu. Can I have the parties announced for the record for the state?
Daniel Escobar from the state of Texas.
Defend.
Alfredo Ortiz for the defendant, George Cantu, Your Honor.
Are you Mr. Cantu?
Yes, ma'am.
Counsel, have you received all the discovery and did you review it with your client?
Yes, I have, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Cantu, I'm showing you what's entitled True Bill of...
Here we see George Cantu, ready to face the music for tampering with an electronic monitoring device. Now the legal stakes are high as the court navigates through the allegations and the habitual offender enhancements. If convicted, he could be facing some serious jail time. The tension is palpable, and the burning question remains, will George's past mistakes define his future? Or will he get another chance to turn his life around?
The electronic monitoring device, what is that, a third degree?
It should be a state jail code.
Okay.
I was looking into it. I know that the statute does have the third degree language, but that's it. It was a intensive supervision. And there was no language like that in our side.
Okay. All right. I'm going to show you what's entitled Court Admonishments and Defendants Waivers and Affidavit of Admonitions. Did you review that with your attorney? Did you understand it?
Yes,
Did
ma'am.
you sign it in all the appropriate places?
Yes, ma'am.
Did you understand you're charged with tampering with an electronic monitoring device under intense supervision? That's a
Yes,
state jail felony, the way it's been indicted.
Yes,
The range of punishment normally would be anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. Did you understand?
yes, ma'am.
All right, you can unfold your arms. You get people nervous when you do that, okay?
It's crucial to understand what's happening here. George is in a tough spot. He's facing both legal consequences and personal battles, including a severe drug problem. His attorney makes a compelling argument, trying to focus on George's character and the circumstances surrounding his crime. However, the law is firm. The habitual offender enhancements could see George's sentence extend significantly. The clock is ticking, and his future hangs in the balance.
Understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call in the right to remain silent. Did you understand by entering this plea bargain agreement you were giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
Yes, he has.
Do you believe he has a rational as well as a factual understanding of the charges against him?
In my opinion, he does.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, he is.
Mr. Cantu, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Anyone promised you anything other than the plea? Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am. Court
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney and did you understand it? The plea punishment is to be assessed at 5 years in the prison. You agree that you've been convicted of 1 or 2 more felonies for enhancement, and there are no applications. Did you understand that to be the plea?
This is a pivotal moment. George, under intense questioning, admits to his mistakes but also sheds light on the struggles he's facing. It's a human story: addiction, family issues, and the desperate need for help. But the court must weigh these personal factors against the crime he committed. It's a tough decision, but it's not just about mercy. It's about justice for the community and safety for the people around him.
All right. And state, is that the plea, the cap of 5 years?
Yes, yeah.
All right. And to correct the record, the plea offer is for a cap of 5 years in the prison. Did you understand?
Yes, ma'am.
All right.
Let's pause here. The courtroom has already heard the facts, but what happens next is crucial. George is offered a plea deal, a potential 5-year sentence with the chance to prove himself. But in the back and forth with his attorney, there's a palpable sense of urgency. Can George overcome his past and fight for a better future? Or is the weight of his mistakes too much to bear? The plea deal is a double-edged sword.
The state would call in the right to remain silent.
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. And with regards to the both paragraphs of the habitual offender enhancement allegation, how do you plead, true or not true?
True.
And that's true to both of the enhancements?
Yes, ma'am.
All right, after reviewing state's exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. The court will find you guilty. The court will find the enhancements true based upon your plea of true and based upon state's exhibits 1 and attachments. Do y'all wish to proceed with sentencing?
Yes, Your Honor.
All right, anything you wish to say on behalf of your client?
Yes, Your Honor. We filed a motion to reduce this state of jail felony to a misdemeanor punishment, Your Honor, 1244A.
Now we hear from the defense, highlighting George's history with addiction. It's a valid point. He's not a violent offender, but his actions speak volumes about his struggles. Still, the court must decide whether or not this is enough to warrant leniency. It's a moment that truly tests the compassion of the legal system. Should compassion for his addiction outweigh the need for accountability?
He informed his parole officer that he was going to take off, unbuckle his GPS monitor, that he couldn't stay there no more. That was November the 7th. He left the equipment there at his mom's house and that was not damaged or anything. 10 days later, November 17th, he self-surrendered to the parole officer. And he was taken to custody and taken to the Bexar County Jail, where he has been there since he was arrested, Your Honor. I want the court to consider that he is not a violent person. He has the criminal history that he has. A lot of that can be attributed to his drug abuse.
As the court moves towards sentencing, it's clear George is in a tight spot. The plea bargain comes with conditions: 5 years in prison, but there's hope for rehabilitation. The judge seems sympathetic to his circumstances but maintains that accountability must be at the forefront. It's a stark reminder that the road to redemption is never easy, and the system doesn't always give second chances lightly.
Next to address the court.
All right, so legally, this cannot be a 1244. So you want to raise, I'm sorry, you're already under oath. So it says in the police report that the device was removed on November 7, 2023, and it was reported as being removed on November 8th. And when I say reported, that's not you reporting it. That's just parole became aware. So what would you like to say?
Well, I took the monitor off on the 7th, and the warrant was issued, I think, to the next day.
Okay. And did you turn yourself in on the 7th?
Yes, no, 17th.
All right. Any questions?
What do you like to say to the judge regarding sentencing?
I mean, I just got a severe drug problem, a bad drug problem, and it really needs help. You know?
Is that why your mom didn't want you living with her anymore?
Yes, doing drugs.
Okay.
Here comes the heart of the matter: the fine and GPS monitoring. The judge weighs in on the complexities of George's homelessness and whether he should face additional restrictions while trying to rebuild his life. The issue of whether GPS tracking is appropriate here, especially considering George's unstable living situation, adds a layer of complexity. The state's position is clear: ensuring safety is paramount. But can George prove he deserves a chance to stay out of confinement? This could define his future.
Telling them that you needed help.
Oh, Matt, called him after, cut it off.
Okay. All right. This is what the court is going to do. The court is going to find you guilty. Court is finding the enhancements true. The court is going to sentence you to 5 years in the prison, give you credit for any time served, and this will run concurrent with parole. Showing you what's entitled defendant's rights. I'm sorry, trial court certification of defendant's rights to appeal. Did you review that with your attorney? Did you understand it? And did you sign it?
Yes, ma'am.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand? All right, we can go off the record. So I want to let you know that I did listen to your attorney's argument. I always internalize what I'm hearing, but at some point you got to be responsible for your actions. You understand? All right, good luck to you.
Thank you.
You're welcome. Who is here for Albert Bishop?
Cole.
All right, where's Mr. Bishop?
He's in the box right there.
Come on down, Mr. Bishop.
Come on down. Here.
And probation, this is an application. Court is calling 2024 CR 1174, State of Texas versus Albert A. Bishop. Could I have parties announced for the record for the state?
Jason Garrett, hand your arm.
Now we're at the crossroads. The decision to impose GPS monitoring could be the tipping point. It's a strict measure, but with a history of trespassing and dangerous behavior, it's a necessary precaution. For George, this could be the hardest part, maintaining control over his actions while under constant supervision. The clock is ticking on his second chance.
And did you sign it?
Yes, ma'am.
Did you review the document entitled True Bill of Indictment with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
You already know.
Mr. Bishop, I'm showing you what's entitled Court Admonishments and Defendants Waivers and Affidavit of Admonitions. Did you review that with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Did you understand you're charged with the offense of stalking? That's a third-degree felony. Range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine.
Yes, ma'am.
If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial,
Yes,
a
ma'am.
right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, ma'am.
Did you understand that Did you understand by entering this plea, you were giving up those rights?
I believe, yes, ma'am.
And did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty, sentence you up to 10 years in prison and up to a $10,000 fine?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
He has, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I think he does.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Bishop, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
I believe so.
Well, I mean, either you are or you're
Yes,
not.
ma'am. Yes, ma'am. Sorry.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Showing you the plea bargain page. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
The plea deal comes with one final twist. George is required to meet certain conditions, including a community service requirement and rehabilitation. But will he be able to meet these demands? The future full of promise or pitfalls? Only time will tell. But today the court has spoken, and George has to make his next move carefully.
Plaza and be within 500 feet of that location.
Yes, ma'am.
Did you understand?
Yes, ma'am.
Did you understand that to be the plea?
Yes, ma'am.
Defense?
It is, Your Honor.
State?
It is, Your Honor.
Showing you the waiver of repeal paragraph. Did you review that with your attorney? Did you understand it? Did you sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, have there been any such motions?
No, Your Honor.
Next, I'm showing you outside the agreement. The state is requesting that your community supervision be for a term of 7 years. There be a TAP evaluation, 200 hours of community service restitution, and no contact with Tricia Robles or McDonald's at 101 Alamo Plaza. Did you understand those were recommendations from the state and the court does not have to follow those recommendations?
Yes, ma'am.
Then to the offense as charged, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence
Yes, Your Honor. State Exhibit number 1 with all its attachments.
No objections, Your Honor.
showing you what's entitled waiver and consent to stipulation of testimony and stipulations. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there will be no live testimony. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, court will find there's sufficient evidence to find you guilty. The court will defer finding of guilt as you've applied for deferred adjudication. Are you proceeding with sentencing?
Yes, Your Honor. I would like to address the court about the fine.
Yes.
He's homeless. We would ask that you probate the fine, all the fine, until he gets a job or gets set up. We would ask that since he's been homeless.
All right, why are you homeless?
Just doing things for my community, the homeless community, being an activist and
No. Why don't you have a place to stay?
I guess for people say that I don't like being a burden to anybody.
No, I mean, if you get a job,
I know.
no, here's the thing. Listen,
Yes, ma'am. Yes, ma'am.
if you get employment and get an apartment and pay the monthly fee for the apartment, guess what? You're not a burden. It's a business transaction. So why are you not engaging in business transactions for a place to live?
I have no excuses to give you. I'm in the process of getting that together.
So why are you homeless? Like, when does this start? Have you always been homeless?
The point of beginning to now, I've been homeless for about 3 years.
Okay, so what were you doing before you became homeless?
Couch surfing.
All right, so why don't you have a place to stay? I still don't understand why you're homeless.
I have no excuses to give you, and I present them to you. And now I do have a reason, a purpose to stay off probation, to pay for myself. I mean, invest in myself.
Okay, counsel, do you know why he's homeless? I mean, sometimes people are homeless because they start using drugs and people are just done and they say,
I think during the time, Judge, no, not necessarily.
And here it is, the final ruling. The judge grants George a deferred adjudication, giving him the opportunity to rehabilitate himself. But the road ahead is filled with restrictions, monitoring, and an uphill battle against his past. This sentence is a chance for George to prove he can turn his life around, but it also sends a strong message. Actions have consequences, and redemption requires hard work.
what is his plan?
To get myself on the ball for probation.
But how are you going to do that?
Getting a job, if it even means for right now, getting paid on,
Didn't you say something about Haven for Hope?
yeah, Haven for Hope, or the means to an end to get a job. I mean, that should be easy.
All
A
right,
purpose? Well, I had no purpose. I had no family to speak of, no kids to speak of, nobody to take care of. And when it comes to investing in myself, well, now I have a reason. So if you give me a chance, of course I'm going to do what's right. I always do what's right.
all right, so here's the thing. No less than 2 times, this person at McDonald's said that you've been bothering her and she doesn't want you there anymore. Is GPS appropriate in this case?
I believe at least initially it should be, Your Honor.
I don't know about that, Judge. I think wasn't this followed at large and there was nothing going on at the time?
No, I really get, every time she says the name, I really can't picture who the person she's kicking.
Well, it's the person where you keep going to McDonald's at 101 Alamo Plaza. She said you were trespassing. She didn't want you there. And it says, victim advised that the same patterns of malicious behaviors were directed towards victim by suspect. That's you.
Yes, ma'am.
They're saying that you would criminally trespass from the restaurant and would typically direct these gestures at her through a large store front window from the sidewalk. These behaviors occur several times a month and cause her to feel unsafe and anxiety. And then that was in August, and you also have the one from October. So I think he needs to be on GPS. How old are you?
20, 50, I'm about to be 52, man.
Yes.
If I really don't need to be on GPS because I really don't have nothing bad against her. She's a manager at McDonald's. And maybe I flicked somebody off through the window that was in there. But really,
All right. See, why are you telling me that she's the manager at McDonald's and you just
Well,
told council you don't even know who she is?
well, I don't know who she is personally to say, but I know after speaking to her, when she gave me, well, yeah, she's the one of the managers at McDonald's.
Judge, I just think that, I mean, we can delve into this, but I think that he's homeless, and I think I'm asking about the fine. And if we can waive that, and I don't think how he's going to pay for GPS. I think that can graduate if we need that later on, but there's been times when it hasn't. I say he's going to be watched over for a while.
He needs GPS. I mean, I understand the situation that people are homeless. I do. But that doesn't give everybody a pass to do whatever they want to do.
Can you give me a chance to prove myself before you put me on monitor?
No?
But then, don't I need to pay some residents for monitor?
What I'll do is we'll see if the fees can be waived, but you need to be on GPS monitor. And we can't do a wait and see if you're going to do well or not. Because if you're back at that McDonald's, I want to know about it.
Okay.
And the only way to know about that, because you say you're homeless, is for GPS.
So
And do not cut off this monitor. You understand?
So the GPS is just to see if I'm in the area of the place?
Yes. What type of GPS do y'all want? Partial tracking?
None.
Oh, it's going to be GPS.
I believe he's tracking so that, I mean, if he is homeless, obviously, that he shouldn't be. I think the state's position is that this particular McDonald's, this particular individual was scared for her safety. And I don't know if you read in there, Judge, is that one of the times this happened, an officer was standing with this individual when it happened.
Mm-hmm.
And so that's the brazenness of that in front of an officer is more concerning to the state. You also, John.
Can I speak on that?
I don't know. Does your attorney want you to speak on that? All right. It's a $1,500 fine. That'll be probated. 7 years deferred adjudication. There's to be GPS tracking. No contact with Trisha Robles. No contact with McDonald's at 101 Alamo Plaza. And you're not to be within 800 feet of McDonald. I'm sorry, you all asked for 500 feet. I think it should be 800. Any objection to it being 800 instead of 500 feet?
I wouldn't know where.
No problem.
Okay. And you're not to be within 800 feet of the McDonald's at 101 Alamo Plaza or Trisha Roberts. I'm sorry, Trisha Robles. There's to be regular reporting by Zoom or in person, regular random UAs, proof of employment within 45 days of release. There's to be no employment as a home health care provider or with minors. There's to be no unsupervised contact with minors. There's to be a TAP evaluation in custody. My understanding that's 2 weeks. Follow TAP recommendations. Field visits. 1 time per month for 3 months. And then at probation's discretion. Probation, is there anything else he needs? Yes. All right. And then there's 200 hours of community service restitution. That'll be waived if you are able to get a certificate or some type of education from a trade school or somewhere else. You understand?
Yes, ma'am.
Is there anything else you need from the court to be successful?
I believe I'm being released on, after monitor.
You are going to be in custody for 2 weeks for a TAP evaluation. Anything else that you need to be successful on this probation?
I'm gonna be put back in jail for 2 more.
Yes, you are. Anything else you need to be successful on this probation?
Okay, so do I have a?
Showing you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it?
Yeah.
Because this is a plea bargain agreement, because I followed your plea bargain agreement.
In the end, George Cantu's case is a stark reminder of the complex balance between justice and mercy. The court has handed down a fair sentence, offering George a chance to rehabilitate, but the path ahead is full of challenges. What do you think of this case? Should the court have shown more leniency, or was the sentence justified? Let us know your thoughts in the comments below. And if you found this courtroom breakdown as intense as we did, make sure to hit that like button, share this video, and don't forget to subscribe for more jaw-dropping legal cases.